He did his time, and then you went and killed him before I could even make amends with him.
You may have seen this explosive sentencing on other channels, but you probably don't know the backstory. And I didn't either until I spent several days digging into it. And man, it's rough and crazy and really, really sad for their kids. So let me tell you about it. This case takes place in Lenawee County, Michigan, which is down at the bottom, not too far from Detroit. Dad is Christopher Lee-Ryan Carden, and it seems he has never really walked the straight and narrow. His criminal record started before he was 18. He actually has a charge on his adult record the crime occurred when he was 17. So he married Jamie Lee, I don't know her maiden name, but she's Carden now, and she admits to starting her drug abuse in her teen years. So they get married and decide that they're going to bring 6 children into the world. I started to summarize this case, and then I realized that I was being redundant because I wanted to read to you the opinion of the Lenawee Circuit Court Family Division from 2022 from an action to terminate the parental rights of these 2 parents. It's from the Michigan Court of Appeals. It's an unpublished decision, and it goes through everything, most of their history. So I'm going to go ahead and just go through that because that's going to give you way more information than I can, and then I will supplement afterwards. So this court action to terminate the parental rights took place after Dad's alleged crime. And just so you're not in suspense, Dad is charged with 2 counts of open murder and a laundry list of other charges. The circuit court terminated the parental rights of both mother and father to their 6 children, names redacted. The court determined that respondent mother had not satisfactorily addressed her substance abuse issues despite years of services and had not sufficiently benefited from services to improve her parenting skills, warranting termination. In addition to unredressed substance issues, the court terminated respondent father's parental rights based on his repeated criminal behaviors. Although respondent mother made valiant efforts to overcome the obstacles to reunification, she ultimately was unable to provide a safe home for her children. Accordingly, we affirm the termination of both parents' rights. Respondents have 6 children, ranging in age from 8 to 12. They also both have an extensive history of substance abuse. Respondent mother has been abusing substances since adolescence. Department of Health and Human Services began providing services and drug screens to the mother in 2012, shortly before the birth of her final child. The DHHS filed the current petition to take the children into custody on June 5th, 2019, when the children called 911 because they could not wake the mother after a 2-day drug binge. On the date the petition was filed, respondent father was in prison for leading police on a high-speed chase with mother and several of the children inside the vehicle. The chase occurred because mother had left some of the children at a drug house and the occupants would not allow the children to leave. Father stabbed one of the home's occupants and the couple escaped with the children. According to an article in The Blade, Mr. Carden led police on a high-speed chase with 4 of his children and wife inside the vehicle. He had failed to stop at a stop sign, and the police officer attempted to pull him over. He was ultimately charged with failure to comply with the order or signal of a police officer, which is a 3rd-degree felony, and 4 misdemeanor offenses of endangering children, and 2 traffic citations. According to the police affidavit, they tried to pull him over around 4 p.m. He violated multiple traffic laws, went on a high-speed chase. He eventually drove off the road, stopped the vehicle, and fled on foot, where he was later apprehended, of course, and was booked into the Lucas County Jail with a bond of $25,000. Just a couple months later, justice used to move way quicker, he was sentenced to 2 years in prison. For that, they dropped 3 of the endangering children charges, and he pled to the rest of them. His attorney said he was on parole in Michigan, and that was the reason why he led police on the chase. He was spooked. He also asked that his client be sentenced to the Lucas County Correction Treatment Facility because he struggled with substance abuse. While in court, Mr. Carden apologized to the court, to the officers, and to his family. This was not father's first incarceration. He has been absent for long periods through the children's lives. Father remained incarcerated until the summer of 2020. A condition of father's parole was that he was not to have contact with mother. Respondents did not comply with this provision. There were allegations regarding two of mother's siblings. The mother also maintained a relationship with an elderly man named Samuel Compton. He provided financial assistance to the mother over the years, and the mother and the children lived with him for a while. The problem is he was a registered offender and had committed offenses against children, which was a known fact by the mother while they were living in the home. He was accused of, while living in his home, Compton is accused of bad things with several of the children. So the children were taken and put with relatives, 3 different relatives, because there's 6 of them. Like, who could take on 6 children? Footnote 1, we note that police investigated the possibility that mother permitted Compton access to the children in exchange for financial assistance. The allegations were not substantiated and charges were never brought. It appears that Compton only avoided prosecution because he died during the pendency of the investigation. Mother completed her parenting class, she did her drug treatment, she did good. Interestingly, she was doing drug screening. She kept coming up positive for cocaine, which was not her drug of choice. She kept insisting that she hadn't used cocaine, and then there was an investigation into the irregularities with the contractor performing the test, but I couldn't find any mainstream articles on it, just that all of the tests had been disallowed from that time period. Then they got a new contractor. She tested positive for marijuana and methamphetamine and won. The court suspended both parents' supervised parenting time in October 2020, based in part on their drug use. During that time, the court didn't reinstate parenting time after its evidentiary ruling. Concerning incidents during the visits convinced the court that reinstating parenting time would not serve the children's best interests. A case report described that the mother had difficulty dividing her attention and appropriately disciplining her children. She frequently discussed topics with her children that were not appropriate, such as past romantic partners, illicit drug use, and frustrations with their father. The mother made promises she could not keep. She also argued with the children about their foster parents and told them that their foster placements were not their homes. During one encounter, mother was upset that her daughter wanted a certain haircut, and mother relented and agreed to the haircut, but afterwards made cruel remarks. There were problems during the father's parenting time as well. He experienced bouts of explosive anger. He frequently expressed frustration towards children during visits, displaying anger and aggressive language, pounding his fists on the tables. He sometimes showed up under the influence. On one occasion, he appeared to purchase drugs during the visit, then went in the bathroom to use them. In fact, the respondent father could not complete a psychological evaluation as required by the case services plan because twice he appeared for the evaluation under the influence. On December 26th of 2020, mother's sister summoned police because respondents were together at mother's home and using methamphetamine. There was a no contact order. The sister reported father had physically assaulted the mother. Father disappeared before the police arrived. Mother admitted that she had allowed father to stay with her for a week. That day, father became angry and that mother had allowed the children to be essayed. Mother described that father threatened to kill her by injecting her with poisoned drugs, choked her, and threw her to the ground. Mother stated that father threatened to kill Compton. On January 7th, 2021, father engaged in a string of robberies in Ohio. He was arrested but escaped custody. Then on January 15th, he fatally murdered 2 people, which is what he is in custody for right now. He remains incarcerated and is awaiting trial. In the spring of 2021, while her parenting time was suspended, meaning she was not to have contact with the children, mother was spotted sitting in her car at 2 of her children's softball games. She approached one of the kids while they were riding a bicycle outside of the home. She had unsupervised contact with her older children over social media. She tested positive for methamphetamine on one occasion. In early May, she was involved in a motor vehicle accident while intoxicated from alcohol. A week later, she tested positive for alcohol in a drug screen. And despite these setbacks, she was able to secure a high-paying job as an LPN, a matter of concern as she would have access to controlled substances. Throughout the proceedings, the caseworker presented significant evidence about the trauma the children had endured in their lives and the lasting impact. The children had all thrived at their relative placements, showing improvement in behavior and academically. They had all joined sports teams and made new friends. The older children were finally able to enjoy their lives without parenting younger siblings. Children expressed divergent views about their desires to maintain contact with mother and father, but all agreed they did not want to return to their care. All three sets of foster parents testified their willingness to adopt the children and continue the sibling relationship and to support the children in the event they desired contact with the parent. Ultimately, the circuit court terminated both parents' rights under MCL 712A, 19B, 3, C, I, and J. The court also cited subsection G, not in terminating the father's rights. Both parents appeal, challenging the evidentiary support of the statutory termination grounds and the court's conclusion the termination was in the child's best interest. I mean, there's so much evidence. There's I know it's a formality to appeal, but there's so much evidence. The court may terminate a parent's parental rights to a child if the court finds by clear and convincing evidence one or more of the following. See, the parent was the respondent in a proceeding brought under this chapter. 182 or more days have elapsed since the issuance of the initial dispositional order, and the court, by clear and convincing evidence, finds either of the following. I, the conditions that led to the adjudication continue to exist, and there is no reasonable likelihood that the conditions will be rectified within a reasonable time considering the child's age. Also, the parent, although in the court's discretion financially able to do so, fails to provide proper care or custody for the child, and there is no reasonable expectation that the parent will be able to provide proper care or custody within a reasonable time considering the child's age. There is a reasonable likelihood, based on the conduct and capacity of the child's parent, that the child will be harmed if he or she returns to the home of the parent. Clear and convincing evidence supported termination of mother's parental rights under factor CI. The children had been in care for more than 2 years by the time of the termination hearing. The main condition that led to this adjudication in relation to the mother was her substance abuse. Mother had yet to rectify that condition despite 9 years of services, making it unlikely she would overcome this obstacle within a reasonable time frame. The record supports that mother began abusing substances when she was a teenager and therefore has struggled with this problem for the entirety of the children's lives. CPS intervened in 2012. The mother was given random drug screenings, access to services to address her substance abuse. However, in 2019, father was imprisoned after stabbing a man and leading police on a high-speed chase. Events stemming from mother leaving some of the children at a drug house. Left alone to care for 6 children, mother continued abusing substances. Her inability to safely supervise her children led to the institution of this action. Although many of mother's drug screens were excluded from the record, there is evidence that mother continued using substances after the time, despite participating in intensive substance abuse services. In August 2020, mother was involved in a car accident linked to mechanical problems. However, mother was also under the influence of alcohol at the time. On December 26, 2020, officers responded to mother's home and noted that she appeared to be under the influence. In spring 2021, mother reportedly tested positive for marijuana and methamphetamine. Despite being ordered to avoid all mind-altering substances, mother was involved in a drunk driving accident in May 2021 and tested positive for alcohol a week later. Mother's position that alcohol was not her drug of choice is completely irrelevant. Mother was substituting one addictive substance for another, with disastrous results. Given respondent mother's extensive history of substance abuse, the lengthy period of services given to her, and continued use of substances up to the eve of the termination hearing, the court did not err in finding that the mother would not be able to overcome the obstacle within a reasonable time to parent her children. Accordingly, the court did not err in finding termination factually supported. Another point of concern identified in the petition was respondent mother's parenting skills. Mother had often placed her children in dangerous positions and failed to adequately supervise them. This forced the older children to parent the younger ones. Further, despite knowing his status as an offender, mother moved her children into Compton's home. Mother completed a parenting class in March 2020. The instructor reported that mother did not show benefit from this program. Indeed, mother's inappropriate behavior with the children led to the suspension of parenting time in the fall of 2020. Mother participated in another parenting class at this time, and a thorough review of the record shows that Mother never addressed the trauma caused to her children by her conduct. Ignoring that trauma and the court-ordered suspension of her contact with the children, Mother continued to appear in the children's neighborhoods, sporting events, and social media feeds. This too supported the court's determination that termination was supported under factor CI. Mother's continued substance abuse, failure to benefit from parenting classes, and failure to acknowledge the trauma caused to her children by allowing a predator access to them also supports termination under factor J. As noted, Mother has already placed her children in danger on several occasions and has never provided adequate supervision. She did not adequately benefit from services provided to remedy these problems. Mother continued to abuse marijuana, alcohol, and methamphetamine even shortly before the termination hearing. She did not benefit from parenting classes and behaved inappropriately during parenting time. From this evidence, the court could conclude that Mother would continue to place her children in dangerous situations and provide inadequate supervision in the future. Some of the conditions leading to the adjudication as to the father were his substance abuse, criminal activity, and violent violent temper. These conditions continued to exist at the time of the termination hearing with no sign of abatement. When Father was released from prison in the summer of 2020, he immediately returned to substance abuse. He overdosed on one occasion, then entered an inpatient drug rehabilitation program, but continued to abuse substances. He could not complete a psychological evaluation because he twice appeared under the influence. Supervisors opined that Father was under the influence at more than one parenting time session. And he actually purchased and used drugs during one visit. Father continued to engage in criminal activity as well. In December 2020, Father physically assaulted Mother. In January 2021, Father engaged in a robbery spree and was arrested. Father escaped custody and then allegedly committed a double homicide. If Father is convicted as charged, he will remain in prison for the rest of his life. During the brief period when Father was able to visit the children, he used aggressive language, yelled at the children, and pounded his fists on the table. Given this history, the court did not clearly err in finding that the conditions that led to the adjudication continued to exist and could not be rectified within a reasonable time frame, and that the children faced a high risk of harm if placed in the father's care. Accordingly, the evidence more than adequately supported termination under both factors C, I, and J. Clear and convincing evidence also supported termination under factor G. Father has been in and out of prison throughout the children's lives. When present, Father has abused drugs and the children's mother. At no time has the father provided a safe environment for his children. Given his continued drug use and criminal behavior, Father will be unable to provide proper care and custody at any point in the foreseeable future. We discern no error in the circuit court's conclusion that three factors supported termination in the father's parental rights. It's really fortunate that they are in a good place now and thriving. I think that's amazing. I'm kind of torn between, did the system work or did the system fail? Because they got them out, but it took them so long to get them out. They suffered so much trauma in the process. It's really sad. Really, really sad. Part of the reason Dad may have been in repeated trouble could have been his association with the Latin Counts. They're a street gang based out of Chicago with a large branch in Detroit. The gang was founded in 1955 by Taino youth who had just arrived to the Pilsen neighborhood of Chicago. Tainos are descendants of Texas Creoles and Mestizos who settled in Texas before its admission as an American state. The term is also sometimes applied to Texans of Mexican descent. The original gang members were all related to one another. They named their gang the Texans in homage to the state they originally lived in. The name was changed 2 years later to the Sons of Mexico City to better reflect their ethnic heritage. The name was changed again in 1959 to the Latin Counts, inspired by the Polish Counts gang that had operated in the nearby Back of the Yards community. During the 1960s, the Counts came into conflict with other gangs in the Pilsen area, such as the Latin Kings. In 1978, the Counts were invited to join the People Nation, a gang alliance formed in the Pontiac Correctional Center. This enabled the Counts to enter a truce with the allied Latin Kings, but street-level conflict continued between the two gangs until the 80s. The Counts opened their largest out-of-state section in Detroit in the 1980s. It became massive by the end of the decade and was one of their largest, most prominent strongholds. Obviously, the gang has expanded outside of Detroit, and a section of Lenawee County made headlines for a 2019 murder that was just finally resolved in 2023. Our defendant, Mr. Carden, was called to testify against the head of the local faction. Yes, his legal name is Count Tereso the Almighty Trevino. He legally changed his name from Terry Lynn. I mean, I can see why he changed it, but I don't know why. He was sentenced to 45 to 85 years in prison back in 2023 for the second-degree murder of Christopher Dickinson, which was gang-related. Back to the original subject of this tragedy, Christopher Lee Ryan Carden was making headlines in Lenawee County all the way back in 2013 when his attorney asked the judge to send him to prison rather than letting him stay in local jail. Generally, there's a certain time frame that you stay in the county-run jail versus the state-run prison. And it has to do with the length of your sentence. If you're only there for a couple months, they usually keep you in the jail. But if you're going to be there for a couple of years, they send you up to the prison. And he was asking the court to put him in the prison instead of the jail because he said he needed the services they provided at the prison and not the jail. They denied his request. And then ironically, 1 year later, he was back for violating his probation with the same thing, drugs and theft. It wasn't long until the high-speed chase occurred in Ohio and Carden was back in prison. While he was locked up in Ohio, Jamie was left to feed 6 children and a drug addiction. It's hard to be a single mother, even without a drug addiction. Sam Compton would give her money and babysit the kids for her, and I think he even gave her a car. One of her daughters told her that he had been inappropriate with her, but Jamie didn't believe her. Sam continued to abuse this child for quite a while. The child told Jamie multiple times, and Jamie told her she was lying and continued to take the children to Mr. Compton's home for short visits so he could babysit them. And she even moved in with Sam Compton for a time. Another man named Ernie Black also began coming around and abusing the same. There's reports that some of the other children were abused as well. The family court had a footnote in their appeal hearing that the police investigated Jamie for trading her child, but were unable to prove that claim. The case didn't close, though. Sam Compton was arrested for criminal conduct in the second degree with a person under the age of 13 and arraigned on 8/10/2020. I'm not sure if he was arrested as a direct result of Carden's daughter coming forward or if his arrest prompted her to speak up. I didn't request the records. I didn't want to know the details. Either way, Dad, Chris Carden, found out about it, and according to his mother, he lost it. As a parent, I kind of understand this. On January 15th, 2020, which ironically, I remember that day crystal clear. It was when I had my very first MS symptom. When you look down like this, you would get this electric shock down your legs. The weirdest thing you've ever experienced in your life. Like if you weren't expecting it, like you just look down and all of a sudden it'd feel like just like a zap of electricity through your legs. I've learned it's called Lamitte sign, and it has to do with nerves in your neck where I have a lesion and all that. But at the time, I hadn't been diagnosed with MS yet. And I was sitting in a conference in Orlando with hundreds of other people, freaking the F out, not knowing what was going on. Anyways, TMI. So Dad was living in a halfway house in Lenawee County and still on probation in Ohio from the high-speed chase. He was about to be rearrested for a theft charge from Ohio, but he escaped custody somehow and he fled. He apparently went to Ernie Black's house to confront him, but there was a large group of people there, so he decided he was outnumbered and backed off. He left Ernie's house and went to Sam Compton's house. He found him there with Robert Brayman. Now, Brayman had no contact with his kids that we know of, but he was also classified as a offender for offenses that happened back in 2010. Mr. Carden was so enraged by what had been done to his daughter that he shot both Samuel Compton and Robert Brayman. Then he posted a Facebook Live bragging that he had killed the child predators. He then stole Brayman's car and fled the area. Of course, he was apprehended not long after and charged with first-degree home invasion for Ernie Black's residence because he did break in, and then first-degree home invasion, unlawful driving away of a motor vehicle, third-degree fleeing and eluding, unlawfully carrying a dangerous weapon with intent to do great bodily harm, possession of a firearm by a felon, another firearms felony charge, and 2 counts of open murder. Dad sat in jail for quite some time as the pandemic slowed the courts to a crawl. Apparently, though, Dad likes to talk a lot. We already talked about him being called as a witness in the Cecil case. He's going to testify again in July because that case ended up with a hung jury. Dad's pretty much turned against anyone and everyone that he can, including his wife, who he blamed for not protecting his children or possibly even intentionally putting them in harm's way. They were divorced in 2022. Jamie was arrested in the spring with charges of possession, malicious destruction of property, resisting, and fleeing. While she was out on a $150,000 personal recognizance bond, she was rearrested in August for charges of and criminal conduct with a person under the age of 13. This is a result of the investigation into Samuel Compton's assault on her daughter and her knowledge of that and failure to act. She was arraigned in November, and we pick up at her pretrial hearing in December. This is December 2022.
Prosecutor, are you my prosecutor, Mr. Hartung?
Myself and Ms. Wise, Your Honor, are both on this matter.
Okay.
They're ganging up on me, Judge.
All right, this is in the matter of the people of the state of Michigan versus Jamie Lee Carden. We have 2 files, 22-20792 FH and 22-21124 FC. I have George Lyons appearing on behalf of Ms. Carden, and I have Douglas Hartung and Jacqueline Weiss appearing on behalf of the people. This is a date and time set for a pretrial in this matter. Mr. Lyons, how do you wish to proceed?
Well, Your Honor, as the court knows, we held a preliminary examination, and I was speaking with Mr. Hartung earlier. Apparently, they're a little behind with the transcripts. So I'd ask to put this matter out until we have our transcripts.
Okay. Any objection, Mr. Hartung or Ms. Weiss?
No, Your Honor.
No, Your Honor.
All right, so I'm going to set this out to March 15, but Ms. Carden, Mr. Lyons is fully aware that if something changes and they need to get you back in sooner, the court will get you in any day of the week, all right? All right, so I'm going to set this for pretrial on both files for March 15 at 8:30 in the morning. And we'll see you back on that day. And Mr. Lyons, you'll do the stip in order to adjourn?
I will, Your Honor. My client did want to address the issue of bond, though given the nature of the charges, I don't know if as a matter of statute, the court has a discretion to consider bond. This is a CSC 1 minor.
Mr. Hartung or Ms. Weiss?
Your Honor, we would oppose any change in the bond at this point in time. It's too serious of a matter. And the proofs at the exam are rather strong as well.
And counsel,
Mr. Lyons, if you would like to file a motion to address bond, we could have a hearing. I don't unfortunately have time to go into length this morning because of the size of our docket.
Not a problem, Judge. I'll do that. Thank you, Judge.
And I'll see you next Thursday at 1:30, Mr. Lyons.
Yes, ma'am. Thank you.
Thank you.
Following this hearing, Jamie didn't have another hearing until April of 2023.
All right, Mr. Goldstein, let me go over a file. All right, this is in the matter of the people of the state of Michigan versus Jamie Lee Carden, file numbers 22-20792FH and 22-21124FC. I have David Goldstein appearing on behalf of Ms. Carden, and I have Christopher Fleming.
Judge, Miss
Hearing.
Weiss wishes to be here on this. I'm letting her know right now that this is getting called.
I can also sit in this.
Mr. Hartung is here. He can step up to the podium. So I'm going to have Mr. Hartung appearing on behalf of the people, and Ms. Weiss, if she pops in as well. This is the date and time set for a pretrial. Mr. Goldstein, how do you wish to proceed today?
Your Honor, if I could take a minute. Before I got into the case, there was a preliminary examination sometime last year. An order was entered to prepare the transcript of that preliminary examination, but either prior counsel never served it on the court reporter or the court reporter dropped the ball. I'm not sure which, but the transcript was never prepared. I spoke to the court reporter about 3 or 4 weeks ago. She's working on it. She was hoping to have it done by today, but as far as I know, it's not done. So we're going to need maybe 2 more weeks. So I do anticipate questions.
Okay, and Mr. Goldstein, you're correct. So I do have an order for transcript of preliminary examination that was filed with the court on March 20 of 23 with an order to have it prepared within 90 days. And you said you spoke to them and it's supposed to be done, so you need another pretrial?
Yes, Your Honor, because I do anticipate some motions.
Okay, Mr. Hartung, any objection?
No objection, Your Honor.
All right, so Mr. Goldstein, I can set this out so you can have time to review June 7.
Your Honor, could we have the same date you gave me on the 5th, which was May, at the end of May?
May 31?
Yes.
Okay, so we will set both of these out for May 31 at 8:30. And Mr. Goldstein, you'll do the stipend order to adjourn on both files?
I will, Your Honor. By the way, you didn't ask for a stipend order on Smith. Did you want me to do those?
Yes, please.
Okay, I will. Your Honor, I do anticipate a bond motion once the transcript is ready. So if I get that quickly, I will call your clerk and set up a hearing.
Not a problem. All right. So Ms. Carden, I will see you back here on May 31st at 8:30 in the morning. All right.
Okay, thank you.
Thank you.
As you can see in the stream, there's a couple wardrobe changes. That's because this took me days to put together. There's just so much. Every time I thought I had everything, I would find something else. And I couldn't believe how much there was. So if you do enjoy this stream, please like, subscribe, share it. Your support is really appreciated, and it's probably going to be demonetized. So any support is greatly appreciated.
You'll be after this one. Let me get rid of Mr. Gold, the gel, and then I'll take this one. All right, Jamie Carden, is that you at the gel?
Yes, Your Honor.
All right. So, Mr. Goldstein, and is this you, Mr. Hartung, or Ms. Weiss?
Both of us, Your Honor.
All right. Okay. All right, this is in the matter of the state of Michigan versus Jamie Lee Carden. We have 2 files, 22-20792FH and 22-21124FC. I have David Goldstein appearing on behalf of Ms. Carden, who is joining us from the jail. And I have Douglas Hartung and Jacqueline Weiss appearing on behalf of the people. This is the date and time set for pre-trial on this matter. Mr. Goldstein, how do you wish to proceed with Ms. Carden?
Your Honor, there was a real substantial delay in these matters because of the fact that a transcript was ordered, I think back in December, but for some reason it was never prepared until I got in the case. I have just within the last maybe week or so received that transcript. My client has been given a copy. And I do anticipate motions based upon the testimony at the prelim. I know she's been sitting there for a long time. One of the motions I'm contemplating is a bond motion. I know she's been sitting there for a long time, but we needed this transcript since I was not representing her at the time. So I would ask for an adjournment approximately 30 days. I'll get those motions filed as soon as possible.
Okay, I can do June 28 or July 5.
Let's go July 5, Your Honor.
All right, so I will adjourn this to July 5 for pretrials and motions. And you'll do the step in order to adjourn, Mr. Goldstein.
I will, Your Honor.
All right, we will see you back July 5 at 8:30 in the morning. Just make sure we get a judge's copy. Thank you, Mr. Goldstein and Mr.
Okay.
Hartung and Ms. Weiss and Ms.
Can
Carter. Thank you.
Can I sign somebody's name to the step?
Yes,
Everybody.
Okay, thanks.
thanks.
Okay.
All right, thank you. You're all set, Ms. Carter. All right, this is in the matter of the people of the state of Michigan versus Jamie Lee Carden, file number 22-20792FH and 22-21124FC. I have David Goldstein appearing on behalf of Ms. Carden, and I have Jacqueline Weiss appearing on behalf of the people. This is the date and time set for a pretrial on both of these files. Mr. Goldstein, how would you like to proceed today?
Your Honor, the last time we were here on these matters, I had told the court we had just gotten the preliminary examination transcript, and I wanted an opportunity to meet with Ms. Carden and prepare some motions. Unfortunately, I got stuck for 3 consecutive weeks in a jury trial and have not had an opportunity to do those motions or meet with my client, so I'm asking for another adjournment.
All right, how far of an adjournment would you like?
I would like, well, Your Honor, the problem is I'm supposed to start another murder trial a week from this coming Monday, the 17th, which should last about a month. So I'm asking for probably the middle to end of August.
All right. Ms. Adams, Ms. Carden is present in the courtroom, so if we could do the notice. I have August 9, August 30, or September 6.
Let's go with August 30, Your Honor.
All right. Ms. Weiss, any objection?
No, Your Honor.
So I will adjourn this to August 30 at 8:30 in the morning. Ms. Carden, and Mr. Goldstein will do the notice because she's present. So we will see you back on August 30 at 8:30. Ms. Carden, have a seat right there and we'll get your notice of hearing. All right.
Apparently, Mom made bond, which was a $100,000 surety bond, so she would have needed a good chunk of money. At the end of June, and by July 18th, there was a bench warrant for her arrest. I'm not sure the reason because that hearing is weirdly missing, but I'm going to assume that she failed a test or something along those lines. So she was back in within 2 to 3 weeks.
All right, Ms. Carden, give me just a minute. We're waiting for Mr. Goldstein. He's with us, but he might be in another hearing.
Actually, I'm here, Your Honor.
Okay, all right. Let me get her file.
Your Honor, can you put us in a breakout room?
Sure. So I'm going to call the case first now. So this is in the matter of the people of the state of Michigan versus Jamie Lee Carden. We have 2 files, 22-21124FC, 22-20792FH. I have David Goldstein appearing on behalf of Ms. Carden. I'm going with Phoebe Neer appearing on behalf.
I was going to say it should be. I was told from Ms. Wise that Mr. Hartung was going to cover this case today. I don't know if he knew what was being called.
Douglas Hartung appearing on behalf of the people. Mr. Goldstein, I did arraign her on the contempt of court the other day. She agreed to set it to today. Did your office receive the paperwork you requested?
Yes, we did. Thank you, Your Honor.
Thank you. All right, so Ms. Carden, I'm going to open up a breakout room for you and Mr. Goldstein and give you an opportunity to speak. So go ahead and use the mouse and click on join the breakout room.
I was downstairs. They sent me upstairs
But it's
Yeah,
more,
I'm kind of just walking around in circles. I think I might have made a boo-boo or something.
No, it's okay. Oh, there you are. All right, so we're back on the record with Jamie Carden. Mr. Goldstein, how do you want to proceed with Ms. Carden?
Your Honor, my understanding is that the warrant was issued as a result of a positive drug test. I believe it was July 14th. My client will acknowledge that she did violate by using cocaine on that occasion.
Okay, so she's going to plead to the contempt court.
Yes.
Okay, Mr. Goldstein and Mr. Hartong, is there anything we can do on the pre-trials today, or are we just setting those out?
Setting it, well, I assume we're setting it for trial, Your Honor.
Okay, all right. So let me get my paperwork. So I have two files. Both, one is an FC and one is an FH. So I assume the FC would be set for trial first, correct?
I would assume that, Your Honor.
All right, so let me pull this out. Ms. Carden is charged with, on this file, let's see here, we got one count of a maximum penalty of life in prison, and count two, conspiracy to commit conduct first degree, which under registration, and also a term of life with a mandatory minimum of 25 years in prison. So those are the charges she's facing. How long do you think you will need for trial, Mr. Goldstein?
Well, Your Honor, it's not that I need a lot of, just a minute, Your Honor. Of course, it always happens. I'm on two different Zooms and the other one is just now coming on. Let me get rid of that one. Give me 1 second.
Okay. I know where I'm at on his list of favorite judges. So Miss Underwood, let me call Mr. Pagan because I do not have Mr. Pagan.
By the way, for anyone wondering, this blob up here, how do we point to it? Up there, that's Roxy. She's fat. She is alive, but she's lazy. And that's what she does all day, every day, until I get up, and then she sleeps in my chair.
Okay, so let me pause you real quick. Let me skip back to Mr. Goldstein. All right, Mr. Goldstein, so Ms. Carden, on the FC file, how many days do you think trial would take on that? You're muted. They did it. Okay.
I'll leave that up to Mr. Hartong. He knows the case better than I do.
Probably
Mr.
2 or 3
Hartong?
days. Probably 3, probably 2.5, but 3 to be safe.
Okay, so Ms. Adams, how far away from now? Do you want it at like
Well, Your Honor,
December?
Your Honor, I think we probably should address the issue of the violation and determine whether Ms. Carden is going to be incarcerated or not before we talk about a trial date.
Okay, well, I mean, worst case scenario, if I give her 93 days, she's gonna be out by Christmas, and I do have trial dates in December. So, all right, so Ms. Carden, raise your right hand for me. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
All right, can you state your full name on the record for me?
Jamie Lee Carter.
Okay, so let me. All right, so Ms. Curtis, we were here the other day and I arraigned you on a contempt of court on only file number 22-21124FC. The allegation is that you tested positive for cocaine from a drug screen collected on July 14th of 2023. So do you understand the maximum penalty if you plead guilty or found guilty of that contempt of court could be up to 93 days in jail? Do you understand that?
Yes, Your Honor.
Now, do you understand that you have a right to contest the contempt of court charge and to have a hearing on it? Do you understand that?
Yes, Your Honor.
Do you understand during that hearing, you would be presumed innocent until your guilt is proven beyond a reasonable doubt? Do you understand that?
Yes, Your Honor.
If you have a right to have all the witnesses against you appear at your hearing, to have your lawyer ask those witnesses questions, or you may ask them yourself, and to have me order any witnesses you might have to appear at that trial or hearing. Do you understand that?
Yes, Your Honor.
You do not have to testify at your hearing, and no one can say anything about you not testifying or hold it against you in any way. Do you understand all of that?
Yes, Your Honor.
On the other hand, do you understand that you do have a right to testify at your hearing if you want to testify?
Yes, Your Honor.
How do you plead to the charge that you violated the terms of your bond by testing positive for cocaine on July 14th of 2023? Guilty or not guilty?
Guilty.
All right. And has anything been promised you to get you to plead guilty?
No, Your Honor.
Has anyone threatened you in any way to get you to plead guilty?
No, Your Honor.
If I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during the hearing, or that it was not your own choice to enter the plea. Do you understand that?
Yes, Your Honor.
Is it your own choice to plead guilty?
Yep.
All right, so Ms. Cardin, when you were arraigned and charged on these files, you were given certain bond conditions. And one of those bond conditions is that you were not to use any illegal controlled substances. Is that correct?
Yes, Your Honor.
Now, on July 14th of 23, you tested, as you were required to, at the Lenawee Drug and Alcohol Monitoring Facility, and the test was positive for cocaine. Was that because you had in fact used the illegal controlled substance cocaine?
Yes, Your Honor.
Okay, all right. And you knew it was cocaine when you used it, right?
Yes, Your Honor.
Miss Adams, could I get the red book too, please? All right, I accept the plea. It has been given voluntarily, understandably, and accurately. The defendant has full knowledge of her rights. She does have competent counsel. Mr. Goldstein, is there anything you'd like to say on behalf of the defense of your client before the court passes sentence?
Your Honor, I'm not going to minimize what my client did. Is any violation of bond, because bond is not something that is easily given or easily earned. But I'm going to assume, for the sake of argument, unless somebody proves me wrong, that she has been testing, and this was the only negative test, or I should say positive test, that she had. And I would ask the court to take that into consideration in passing sentence. I think 10 days is probably an appropriate sentence for this violation, if in fact this is her first positive test.
All right, Mr. Coast, is this the first time she's tested positive?
Judge, it was the first time she tested positive, but after her positive, she missed 6 consecutive tests. It's my belief too that she moved and she did not give me her new address, would not return phone calls. Yeah, it's a pretty serious violation.
All right. Mr. Goldstein?
I didn't have.
Nothing else. As far as the not giving a new address, that's news to me. I didn't hear that prior to now, but.
Well, she wasn't violated for that. Okay.
Correct.
All right, Mr. Hartung, would you like to weigh in?
I think Mr. Coast's point is very well taken. And I think, I mean, it's not on this calendar for today's hearing, but I was advised that an independent investigation revealed that she was around minor children again, and maybe subject to a future bond issue. But, you know, Mr. Goldstein's correct. Bond is a privilege, and she flat out violated the bond conditions. She's shown elements of a drug problem in the past. It caused some problems with her children, and she violated those terms. I think she should probably be given the maximum sentence here, Your Honor.
All right, Ms. Cardin, anything you want to say on your own behalf?
I did not have a phone. I wasn't not answering phone calls. I didn't have a phone, and I had to move. The lady kicked me out of the hotel. I had to move, and I didn't have a stable address. I was just staying with people. That's why I didn't have an address until I found a place.
Okay.
My phone got broke and I didn't have a phone. So I wasn't not answering phone calls. I just did not have a phone.
So Ms. Cardin, why did you not, well, I'm not even gonna ask you. All right. So Ms. Cardin, you're facing a minimum of 25 years in prison. 25 years, which means that if you were found guilty, you would be released from prison when you are a much older woman, probably 60s, right? So bond conditions, I take them seriously. I know your attorney does. And I know that Mr. Coast is really helpful and he works with people. And I'm sorry, I just find this pretty egregious in the face of what you're facing in your prior history. So it's a sentence of the court that you will serve 60 days in Lenawee County Jail, and I'll give you credit for you've been in jail 3 nights.
No, I've been in jail for 2 weeks, but I do have 11 months prior.
This is just on the contempt. So how long have you been in jail on the?
17.
The 17th. All right, we will give you credit for time served to the 17th, but it'll be 60 days in jail on the contempt of court. All right, so Mr. Goldstein, I know that your schedule is busy. Do you have December 19th available?
Judge, the only thing I have in December is just a moment, let me get to December. I looked a minute ago. Is I have a jury trial on the 12th, which is the week before, so I should be done by.
Hold on, can I pause everybody for a moment?
Sure.
All right, I have, is it ready? Hold on one second, please. Thank you. All right, sorry. All right, Mr. Goldstein, I'm sorry. Could you repeat that?
Judge, I do have a jury trial scheduled for the 12th, which is the week before, which should be done. The only concern I have with the 19th is that is the week before Christmas. I don't know how that's going to impact your ability to get a jury panel. Given that this is a capital offense, you need a large panel.
You said, what was the start date of your
The 12th.
trial?
The 12th. Now I can do the beginning of December, I could do the week of the 5th, 4th, 5th.
I can do December 5, 6, and 7. I have some other trials scheduled. Those people are not in custody.
Yeah, I can do that, Your Honor.
All right, so you will do December 5, December 6, and December 7. December 5 is a Tuesday, so it would start at 9 a.m. I can set a final pretrial for November 15. Are you available that day, Mr. Goldstein?
Since it's by Zoom, Your Honor, shouldn't be a problem.
All right, at 8:30 a.m. Okay, and I will set a motion deadline for, let me find this here, mix things up. Motion deadline of November 22nd. Just because the holiday for Thanksgiving might mess things up. And then I'm going to ask that jury instructions be provided to the court by November 22nd. So by November 21, so that if we need to review them on the 22nd, or no, hold on, let me back up. I guess I would ask that they be due by November 14, so that we can review them if we need to the day of the pretrial. So that would be jury instructions and voir dire questions, November 14, 23. And then I will set her other file for pretrial on the 15th as well.
Anyways, I'm going to give you another trigger warning because they're not going to talk very graphically, but they're going to allow the victim to speak, and it's going to rip your heart out. So if you don't want to hear it, now's the time to skip forward.
Do you need a moment for her to look? Is that her statement?
Yes, sir.
Oh, okay. This is in the matter of the people of the state of Michigan versus Jamie Lee Carden. We have files number 22-20792FH, 22-21124FC. I have David Goldstein appearing on behalf of Ms. Carden. I have Douglas Hartung and Jacqueline Weiss appearing on behalf of the people. This is the date and time set for sentencing in this matter. Mr. Goldstein, I was handed a victim impact statement this morning from one of Ms. Cardin's daughters. Just a reminder for purposes of this hearing, you need to make sure that you use initials and not minor children's names, all right? Yes?
Yes, sir.
Yes, sir. I'm supposed to record this according to my judicial attorney. All right, so Mr. Goldstein, did you receive a copy of the pre-sentence investigation report?
The corrected one, yes, Your Honor.
All right. Was that the one emailed 12/21?
Yes, Your Honor.
Okay, and Ms. Weiss and Mr. Hartung, you also received it?
Yes, Your Honor.
Yes, Your Honor.
All right, very good. And Mr. Goldstein, have you had an opportunity to read, or Ms. Carden, have you had an opportunity to read and review the pre-sentence report with Mr. Goldstein? Are you satisfied with Mr. Goldstein and the advice that he has given you?
Yes, sir.
Mr. Goldstein, do you wish to explain or challenge the accuracy or relevancy of any information in the pre-sentence report?
Some minor changes, Your Honor. I changed the sentence date on the cover page to 1/26/04.
All right, that will be corrected.
I corrected the jail credit on the file 22-20792 should be 29 days. On the other file, on each count, it should be 543 days. Since we have an agreement that all the sentences will be concurrent.
Okay, so that would be 22-21124FC.
Correct, Judge. Sorry. And then in the body of the report, my client, it's not really an error, but back where it indicates that she received a nursing degree or certificate.
Right, yes.
We placed the name of the colleges there. It's Northwest State Community College. She indicated it was in Archibald, Ohio. Clearly, there's one in Michigan also.
All right, we'll make note of that. Ms. Weiss or Mr. Hartung, do you wish to explain or challenge the accuracy or relevancy of any information in the pre-sentence report?
No, Your Honor.
I'm
Okay,
sorry, Your Honor. On page, there's one of them, on page 9, where it talks about marriage narrative, it indicates that there are it says here that there are 3 children with Chris. Tiana is not Chris's daughter.
okay. All right, so we will strike that. Okay,
I think that's it, Your Honor. Sorry.
okay. Does the pre-sentence report disclose any prior convictions in which there exists any known constitutional defect?
No, Your Honor.
Probation Department has computed the minimum sentencing guidelines on file number 22-20792FH, count 1, police officer fleeing 4th degree, to be 2 to 17 months. Do you agree with that computation of guidelines?
Yes, Your Honor.
Ms. Weiss?
Yes, Your Honor.
On file number 22-21124FC, count 1, assault with intent to commit great bodily harm less than murder, the probation department calculated the minimum sentencing guidelines to be 34 to 67 months. Do you agree with that computation of guidelines?
Yes, Your Honor.
Ms. Weiss?
Yes, Your Honor.
Okay. And then on file number 22-21124FC, count 2, or 1st degree, I'm sorry, the probation department calculated the minimum sentencing guidelines to be 135 to 225. Do you agree with that calculation of guidelines?
1 second, Your Honor. I circled PRV 5, and now I gotta remember why I did that. So just give me 1 second.
Okay.
That would be prior. I believe PRV 5 is prior misdemeanors.
Ms. McGrain, could I get my guidelines book? I think I took it back for something.
Your Honor, I think the reason I circled it was that one of the prior misdemeanors was a possession of marijuana charge. And I know that in some courts, that's no longer considered a conviction. Other courts take the position that it was a crime at the time, and so that doesn't change as far as prior record is concerned. But my understanding from a lot of literature since Michigan legalized marijuana, that they no longer consider possession of marijuana to be a criminal conviction.
You're saying PRV 4?
I'm sorry, I've got it circled PRB 5.
Oh. Ms. White,
Your Honor, it is a prior conviction and I believe it should be scored.
Mr. Goldstein, at this time, it's still showing up as a conviction and it may very well get set aside, but at this time, I'm gonna leave it on the scoring.
Well, Your Honor, my understanding is that the state took an action some time ago to eliminate all possession of marijuana convictions. I realize it's, I mean, you'll find it if you look, it's certainly there, but my understanding is when they changed the law, that they went in and basically wiped out all possession of marijuana cases.
They're working on that.
No, Your Honor,
It
it doesn't change.
doesn't change.
All right, so any objection, Ms. Weiss?
No.
All right, so we will mark that as 0. This.
Takes it to 20.
We'll change PRB 5 on child abuse first degree to 0.
Wait,
No, maybe, no.
It does
It
change
does.
the guidelines. Your Honor.
Okay.
Makes it a C grid rather, I mean, a C rather than the D category.
Do you guys want to take a break and go look at this?
yes, please.
Okay, so Ms. Carden, why don't you go have a seat over there? Mr. Goldstein and Ms. Weiss, why don't you step in back? Do you want my guideline book?
We got, but that's actually easier.
Can you give this to Mr. Goldstein?
Actually, I don't think, Judge, I don't think we need that. The only question is whether or not that possession counts. If it does count, the guidelines are what they are now. If it doesn't count, it changes the guidelines.
Very minimally.
Yes,
126
I just
to
looked
10.
at, yes, we just looked at the new range, it's 126
So
to
it's
10,
still
so
within-
we're gonna consent to getting rid of that 5 points.
So the guidelines will now be, all
Range that we
right,
talked
Ms. Carden, you go back up. So 126 to what?
210.
All right, Ms. Walsh will make that addition.
Yes.
Change. Change. All right, sorry about that. All right, very good. So we'll make that change. Anything else for the guidelines?
No, Your Honor.
All right. Ms. Weiss, do we have anyone here that's going to speak today?
I do. Do you want me to call her CC or do you want me to state her name for the court?
You can use her initials.
Okay, I do have TC here to speak.
All right. 1 second. Okay. So could someone adjust the microphone for her? Thank you. No, Mr. Hartung, can you bend it down? It bends. Okay.
Can you hear me?
I can hear you. So I need you to look at me and then you're gonna read a letter. Okay, so Ms. Weiss already told me who you are, so you don't have to state your name, but you can make your statement now, okay?
Well, my name's in part of it. Do I still do that part?
No, you don't have to say it, but you're very soft-spoken. So I'm gonna need you to speak as loud as you can, okay?
Okay.
Okay. Do you want someone to read your statement for you? Would that make it easier?
Sorry, the youngest stuff.
All right, I'm gonna pause you 1 minute, Ms. Spade. We're not picking up any audio for her, and I understand we have a recording system now. But can we get a copy of that statement afterwards for Ms. Spade's benefit?
Yes.
Absolutely.
Would that help, Ms. Spade? Okay.
I can't hear it.
I can't hear it. There's nothing I can do about that. Okay. Okay. We can attach it to the file. All right.
I am Lisa Jacob, I'm a daughter. I'm 12 years old. I lived with my mom from birth until I was 8 years old. For most of my life, my dad, Christopher Carter, was in jail and prison. Then my mom tried to me and my 5 siblings. It was for the first time I was sexually assaulted. The sexual harm went on for about 5 years.
It's okay. It's okay. Do you want someone else to read it for you? It's okay. No?
Stop this from happening. When I needed her most, she shut me out and said it didn't happen and that I was right. I will never forget the thing that Ryan Walter did to me. I have been an individual in therapy for more than 4 years. I've had countless nightmares for a very long time. It is still very hard for me to talk about the things my sexual assaulters is to me. It will take a very long time for me to heal from traumatic experiences in the past. I tried very hard to hate my mother when she did things, but I can't because she's my mom and I will always love her. That makes me think she put me through even harder.
Thank you very much. The record should reflect that I was provided a victim impact statement this morning and that I was able to hear the young woman enough to state that everything she said was in that victim impact statement. Is that correct, Mr. Goldstein and Ms. Weiss?
Yes, Your Honor.
Okay.
Yes, Your Honor.
All right. Anybody else?
No other victims.
All right. So you were very brave, and I'm very proud of you for being able to get up there and do that. All right, Mr. Goldstein. Ms. Weiss, do you want to reserve a statement after, or would you like to make your statement now?
Yes, Your Honor, I'd like to reserve my statement.
All right. Mr. Goldstein, is there anything you'd like to say on behalf of your client?
Yes, Your Honor. This is a fairly unusual situation in that you cannot deny that certain things happened. There's no question that they did. But this is not the person, meaning Ms. Carden is not the person who did those things. That's not what she's accused of. She's not accused of doing things. She's accused of not doing things, which is not protecting her children. The context of this, Your Honor, is that my client is not an evil or a bad person. My client was gripped by an incredibly intense addiction to drugs. The pre-sentence report indicates not only the amount of drugs that she was doing, but the type. She was doing cocaine, she's doing morphine, she's doing heroin, she was doing alcohol on a daily basis. Some of them starting from when she was 13 years of age. And the problem, Your Honor, is that never having been a drug addict, I think it's hard for me to understand, and I think anyone who's never been a drug addict to understand the power and the control that hard drugs have over someone's life. As the court is well aware, having read the reports and having heard the plea, my client was allowing other individuals to do things in order for her to feed her habit. Now, I'm not excusing what she did. I'm not trying to justify what she did. I'm trying to understand what she did, why a mother would allow this to happen to her children. And again, I don't think I can answer that question, at least not for myself, because I've never been a drug addict. I don't know what that's like. I've never been addicted to alcohol. I've never been addicted to heroin, cocaine, etc. So I don't know what that feels like, but it must be awfully strong and awfully powerful to have created the situation that was created in this particular case. So I'm not asking the judge, the court, or anyone else to pat Ms. Carden on the back and say, you were a good mother. No, what I'm saying, try to understand what she was going through and understand that if it had not been for the drugs, this probably would not have happened. And so what the court should be looking for, yes, there has to be some punishment. My client understands that. But there also has to be some understanding that this is not an evil person that needs to be locked away for the rest of her life. What she needs is rehab, treatment, and help in breaking that addiction. Now, certainly, having spent the last 540 some odd days in jail, she is probably drug-free right now. But we need to understand that there's an attraction out there that's going to grip her again once she gets out of prison, if we don't address that issue. So I'm asking the court to give her the lowest sentence the court feels is appropriate.
Ms. Carden, is there anything you'd like to say on your own behalf?
First and foremost, I would like to thank.
Okay, so hold on a second. Mr. Goldstein, could you perhaps move the microphone down a little bit? Ms. Carden, take a deep breath and then make sure you speak loudly enough that we pick it up on the microphone, okay?
First and foremost, I would like to take the time to apologize to my children, family, of course, for all the pain and suffering I have caused. The time I have taken away from people, not only during my incarceration, but also prior to that because of my addiction. I like to throw myself at the mercy of the courts during my sentencing. Your Honor, as you see, I have a severe addiction problem. After 16 months incarceration, I can finally admit I want and need help. I feel prison doesn't help people with addiction and mental health problems. I'm begging for a second chance at life. I'd like to do a long-term inpatient dual diagnosis treatment center. I realize my mental health is my #1 trigger. I know it's a lot of work and recovery, but with the right support, I know I can and will do it. I'm 37 with a college degree and have never been in trouble before this. I can promise I will never get in trouble again as I have learned my lesson. I've already lost everything due to my addiction to choices I've made, including my children, my family, my career.
Twice.
Your Honor, I know usually only one prosecutor speaks, but I'd ask the court to allow me to say my piece as well as Mr. Hartung. I would like to indicate for the court that we heard this morning that Ms. Carden was convicted based on her failures to act instead of an act itself. Jamie Carden was notified multiple times. Sam Compton and Ernie Black, it's not that she failed to protect them. She put them in situations to be around those sexual predators. She indicated she did that because she was getting money, vehicles, whatever she needed to feed her drug habit. That's not a failure to act. That's a willful act to put your child in those situations. First time that I met the young lady that stood before this court to speak to you, she couldn't have even reached my shoulder. Over the years, I've watched her growing into a beautiful, strong young woman. And I've heard about the awful things that she's been through. So to suggest that this is just something short of evil, I don't agree with. And I'm asking the court to sentence the 12.5 to 40 years.
Mr. Hartog?
So because we did a lot of this work in advance in terms of what we're doing today, in terms of the actual numbers of sentencing, the court's choice today is somewhat limited on these matters. And the court is really deciding, I believe, decide on the bottom end of this sentence for the child abuse charge between 10 years and 12.5 years. And the very thorough, very concise report compiled by Jennifer Walsh lays out very, truly significant reasons why to follow her recommendation, which includes the 40-year cap, 40-year maximum cap on the top, and the 12.5-year recommendation on her part as well. And for the reasons what I'm saying, what the court has heard today, what Ms. Weiss has said, and what the victim has said, those are all very well supported. What I want to say directly is that the breadth and scope of the tragedy that was put in motion by Jamie Carden's drug addiction borders on mythological Greek tragedies. Let's take a look at what happened here because she has a drug addiction. She basically sold her daughter for drugs. Her daughter was because the defendant has a drug addiction. Because the defendant has a drug addiction, the victim's father, in cold blood, murdered 2 men and almost a third, and almost murdered the defendant. He testified as such at the preliminary examination that occurred in this case.
I'm sorry, you can't talk right now, please.
What Ms. Carden said was he tried to kill himself too.
He was doing a murder-suicide is what he was doing.
And that's all very accurate. The man that he didn't kill, hold on. The man that he didn't murder went to trial, Ernie Black. And the victim testified in that case. And the victim testified in the preliminary examination for that case. And she was strong, and she told the jury what happened. And Mr. Black was convicted of, first degree. And because he had a prior in the first degree or third degree, he is now imprisoned for the rest of his life without a chance for parole. This is the kind of victim that we have in this case. She is strong and she is courageous. And when it was time for Mr. Black to be sentenced, he had a letter written out just like she had today. And again, she had some difficulty at first. And I remember in the hallway, and she didn't want to do anything. So I said, are you ready to go in and bury this son of a bitch? She went in, spoke with courage, just like she did today, and with a higher volume than she did today. This has gone on for a long while. Ms. Weiss is correct. It was first started out with Ms. Borders, myself, and Ms. Weiss. We have literally watched her grow up into a very brave young woman, all because of what happened. And I'm sure that's bittersweet from their perspective, probably sad from their perspective, because if she did not know Ms. Borders and Ms. Weiss and myself, she would not be here today. Heaven can what happened. But she has emerged out of this much more than a survivor. She's a hero.
Thank you.
And I may make a few remarks after hearing this.
Sure.
As the court knows, I've known Mr. Hartung for many, many years. And I've always respected Mr. Hartung for, among a number of reasons, his professionalism. And that showed here today. Because when he addressed the court, he didn't say that all these terrible things happened because of my client. He said all these terrible things happened because of her drug addiction, which is exactly the same thing that I said to this court when I addressed the court a few moments ago. Jamie Carden is not a bad person. Jamie Carden doesn't go out looking to do bad things, but Jamie Carden had a terrible drug addiction. And that's where if you want to talk about blame, at least 80% or more of the blame rests with that addiction and not with Jamie Carden. Now, he also went on, one thing that I do disagree with that he said to the court. He talked about Chris Carden, and he somehow seemed to feel that Chris Carden only did what he did because of my client, and that's not true. When you want to talk about someone who made a conscious choice to do something, Chris Carden picked up a gun and killed people and tried to kill this person standing next to me, and she's not responsible for what Chris Carden did, nor is her drug addiction responsible for what Chris Carden did. One person in this world is responsible for what he did, and that's him. The court can address him when the time, I assume, I don't know if you have it or Judge Olsaver does, but that will be addressed at the appropriate time. But this is the person, Jamie is the one being sentenced today, not Chris.
In determining the appropriate sentence in this case, the court has considered the seriousness of the offense, your history, the principal proportionality, the statutory penalty, the cost of confinement, the sentencing guidelines, the report and recommendation of the probation department, as well as what has been said upon the record at this hearing. The criteria and reasons for the sentences are the nature and gravity of the offenses, the discipline appropriate to their commission, deterrence against repetition by you and by others, the potential for reformation, vindication for law, and the protection of society. It is the sentence of the court that on file number 22-20792FH, you will be sentenced to the Michigan Department of Corrections for a period of 1 year, 4 months to 2 years with credit for 29 days. And that is on the fleeing fourth degree charge. Let's see, you will pay a crime victim assessment fee in the amount of $130, DNA testing fee in the amount of $60, and a $68 state cost. On file number 22-21124FC, on count 1, assault with intent to do great bodily harm less than murder or by strangulation. It is the sentence of the court that you will serve 5 years to 10 years with credit for 543 days with the Michigan Department of Corrections. There is a crime victim assessment fee in the amount of $130 and $68 in state costs. On file number 22-21124FC, count 2, first degree. It is the sentence of the court that you will serve a period of 12.5 years to 40 years with the Michigan Department of Corrections with credit for 543 days already served. There is a crime victim assessment fee in the amount of $130. Ms. Walsh, do I assess the $60 DNA fee on each file or just one? I think it's just one, isn't it? Just one, okay. During the term of your incarceration and parole, you will obey and comply with all the provisions required and engage in substance abuse as well as mental health counseling. Is there anything else, Mr. Hartung, Ms. Weiss, or Ms. Walsh?
No, thank you.
All right, so Ms. Carden, my bailiff is going to bring down to you two sets of your notice of right to appellate review. There's one set for each file. I need you to initial and date the top copy for our records to acknowledge that you received the paperwork. The other copies are for you. If you wish to appeal your sentence, you would fill out the information on the form and mail them to the address listed on the form within 42 days. Ms. Walsh, the victim impact statement that was read on the record today, I want attached to the PSI. Okay. And to the young lady who spoke today, you can't pick your parents when you're a child. You can't choose who your parents are. You can't choose most of the things that happen to you, but you can choose the future you will have. And you're sitting there with some wonderful people who will help you do that. I wish you the best of luck. Thank you.
The headline read, "Sold her daughter for drugs." And then the story ended. That's how she will be remembered. Addiction is powerful. But is there a line? Is it powerful enough to make you lose all sense? Powerful enough that you would do something that heinous and evil? I can't answer that question because I've never experienced it on that level. And then it's Dad's turn. The local newspapers kept up with the case. They reported on the repeated delays. Most of them were resulting from that thing that shut down the world, and his attorney had some health issues. Then there was a psychological evaluation ordered, which is often seen in murder cases. A normal person thinks you have to be somewhat crazy to commit an act like that, right? To take another life. There's also the fact that Mom testified Dad was planning to take them both out, which he essentially did. But fortunately, they're in a concrete box up above the ground and not below, so their children can still visit them one day and get the closure that they need when they're ready. That's important because they're the victims. Chris Carden's mother spoke out and said he just snapped when he heard what had happened to his child. And I think any parent kind of understands that. When you hear someone harmed your child, you kind of go into wild mother bear mode and want to protect them at all costs. However, there's limits. There was actually people protesting outside of the courthouse on his behalf. The Facebook responses showed support for him with comments like, "Thank you, sir, hashtag no more pedophiles," and "Chris did what most fathers would have done." They apparently set up a GoFundMe that was taken down. It's against GoFundMe's policies to raise money for the legal defense of someone convicted of financial or violent crime. In May of 2024, Chris Carden finally headed to court for his sentencing. He had accepted a plea deal just like Mom.
All right, we are on the record in file 21-20304-FC, People versus Christopher Lee Ryan Carden. We are here today for sentencing in this case, and we are proceeding today by video conference and also in person. First, let me ask the attorneys to place their appearances on the record, beginning with Mr. Hartung.
Thank you, Your Honor. Good morning. Doug Hartung, appearing today for the people.
James Sterling on behalf of the defendant.
And sir, you are Christopher Lee Ryan Carden?
Yes, sir.
Mr. Carden, this is a sentencing in a felony case. As a result of that, you have a right to be present in person in the courtroom for your sentencing hearing, but only proceed by video conference if you're willing to waive that right and continue by Zoom as we're doing now. Are you willing to do that?
No, sir.
All right. We will contact the jail and ask to have you brought over.
All right, thank you.
So at this point, Mr. Carden, you had an opportunity to read and review your pre-sentence report.
Yes, sir, I have.
You had an opportunity to discuss that report with Mr. Daly.
No, sir. I'm not, I wasn't aware that my sentencing was going to be today. My sentencing date has been adjourned for the last year and a half. And as you can see, I don't have no family support out here. No, I wasn't prepared to be sentenced today. This was thrown at me this morning, and I wasn't even made aware. Mr. Daly haven't come talk to me all week because he said he wasn't aware that I was getting sentenced today. I haven't even gotten the court paperwork, and 6 months. I had no clue that I had a court date today. And like, I just asked if I could get even to this afternoon so I could get my family around so that they could be here for support for me. I was under the impression I wasn't getting sentenced until August, July.
All right, at this point, the court does have a stipulation in order in the court records adjourning the sentencing hearing to today. That was agreed to by both prosecution and defense. And it would be mine then to proceed with, it has been appropriately noticed.
You have my signature on that document.
Does not require your signature, sir.
I've been made aware of that document. You're trying to tell me.
You're represented by an attorney and your attorney signed the document. So that is what is required in terms of adjourning the sentencing.
Well, then I need ineffective assistance in counsel because I was not made aware of this court date, sir. I've been adjourning my court date for the last year and a half. And then now it gets sprung on me this morning. My family, as you can see in here, you think my family wouldn't be here if they knew I was getting sentenced today. And I have a high profile case, they would be here. My family, I have family support and they're not here. And so I was not made aware of this court date. When my last thing that I even had, and Doug Hartung can attest to this too, the prosecution, my thing was that he said for me till August. I haven't seen Mr. Daly, sir. And I'm not trying to be rude or anything, but I mean, you're about to take my whole life from me. And I deserve a chance to have family support. And I was not made aware of this court date. I did not know nothing about this court date. They probably thought they didn't even have it adjusted in their system at the jail for this court date. The jail didn't even know about this court date.
Sir, your objection to proceeding today is on the record. If you would like more time to discuss the pre-sentence report or any other issues with Mr. Daly, I'll give you that. But I am going to proceed today.
Like this afternoon?
I'm proceeding right now.
He can have 20 minutes to talk to Mr. Daly. If he needs to.
Your Honor, Mr. Cardin and I already talked several times about this, but everything that Mr. Cardin says here today is basically correct. He didn't think the sentencing was going to go today. I did not believe the sentencing was going to go today. He still has individuals that he is going to testify against. Originally, his sentence was going to, at least the recommendation from the prosecutor's office, in large part were going to be determined about his cooperation in other cases. And in several cases so far, Mr. Cardin has provided information and testimony to the prosecutor's office on several cases. I think he's been an asset to them in that. And I know the prosecutor's office always keeps their word, and they've indicated that they were going to reflect this in a sentencing. The problem is, I don't think the prosecutor really had much more notice about this than I did, as far as the fact that there's been problems at the jail, and now they're hurrying the sentencing up. What I think the prosecutor or the state wants to do in this case now is sentence Mr. Cardin, and with a understanding that when he finishes his testimony, he can come back to court and ask to have a resentencing. It relates to the facts, the allegations, everything. Mr. Cardin and I have been over this many, many times in the past. But so right now, I understand there's issues at the jail that's going to require a sentencing. I understand that. And if the prosecutor's going to leave room for Mr. Carden to come back and be resentenced after he has finished his testimony in his other cases, I guess the only difference that would really mean is that he would be incarcerated at DOC rather than at the jail until those times occur. But he doesn't have his family here. He doesn't have anybody here. We haven't been able to have those kinds of conversations because I didn't believe it was going to go today. I think this is I don't know, there's been several adjournments on it. It's nobody's fault other than the fact that we're trying to get this resolved, and we still are. But that's where my position is at right now. We are here. I can proceed to sentencing if the court requires it. I think the court's going to require that. But I just wanted to put those things on the basis before we proceeded any further.
Much of what he said is accurate. It is true that Ms. Weiss and myself have gone to bat for him with the sheriff and with the jail command. And we did so numerous times because Mr. Carden continuously cannot stop getting in trouble at our jail. And it is also true that we would love to have an opportunity to have him present to the court all of the things he has done so the court would have a full picture of what he's put into this. But at our last meeting here in this court, the last time we adjourned this, it was very clear that he was out of chances. I myself spoke to Mr. Carden on the second floor of this building and told him that you are out of chances. And something happened at the jail relatively recently, and that was it. We had to tell the sheriff that we have to go forward and get Mr. Carden sentenced, whether it be today, this afternoon, or another day, but we have to get it done because he has violated the agreement that we made with him at that point in time. I continuously and firmly will tell the court everything he has done. I will always do that. I will always honor Mr. Carden in that respect and make sure that this court is aware of what he's done. It will take away some of the penalty, perhaps, of the very heinous crimes that he has committed here, but it certainly won't take all of them away. The court has every right to sentence him today. Mr. Carden was aware that if something happened at the jail one next time, we would have to go forward and sentence him. We were advised that something happened. We received police reports to that effect. Something did happen. He violated the agreement. Therefore, it is appropriate to sentence him today for another time that this court determines.
Though, with respect, after that conversation, I haven't had no incidents. I'm still in Orange. I haven't saw nobody. I haven't did anything. I've had no incidents since me and Ms. Wise and you had that conversation. I have no incidents.
We were, just so the court's on the record, we were apprised otherwise it wasn't an assaultive incident, but it was an incident involving conspiracy and drugs and things of that nature.
I had nothing to do with it.
Mr. Carden has become a snitch, like a really good one. And he's been testifying against people like his now ex-wife and the murder trial that I told you about earlier with the head of the local faction of the Latin Counts. And there's quite a few other trials coming up that he has information on. The problem is that he keeps getting in trouble at the jail, which is not allowed when you're working and getting benefits and lesson time and things like that. As part of your cooperation, you have to behave. It's really hard to behave in jail when you're a snitch and a former gang member because there are quite a few gang members in jail and they're going to target you. So he probably has a massive target on his back and a bounty on his head.
I'm going to take a few minutes recess.
The judge returned to chambers for about 30 minutes to make his decision, then he returned.
Back on the record in file 21-20304-FC. I have had an opportunity to consider situation and consider what's been said on the record here this morning based on what I have heard from Mr. Carden and is not having had an opportunity to arrange to have some people who may have something to say in support of him. I don't know exactly what the situation is, but what I'm going to do is adjourn this until 3 p.m. I would suggest that the
I won't be available at 3 p.m. Your Honor. I'm supposed to be in Jackson. I've got other issues going on. This afternoon will not work. At least very difficult for me to make it work. And I won't be able to work on it, but they're waiting for me downstairs. I won't be able to even get to Carden until this afternoon. Then I've got to call his family, those type of things. And also, Mr. Carden now doesn't believe that he's getting the benefit of his plea bargain.
Yeah, I'd like to withdraw my plea, sir.
What is the basis for the request to withdraw the plea?
I don't feel this,
You're represented by an attorney. Your attorney needs to speak for you.
I'm sorry, sir.
I'm sorry, Your Honor, I didn't hear you.
You need to speak for Mr. Carden. He's represented by an attorney. He's not allowed to
I
address the
understand.
court directly. I want to know what the basis for the request to withdraw the plea is.
Plea is, Your Honor, Mr. Carden pled guilty. After he had pled guilty, and he realized the consequences of his guilty plea and what he was facing, he entered into a series of conversations with law enforcement prosecutor's office, many of which I wasn't involved in, one of which involved the case of State versus Trevino, among others. And obviously I wasn't involved in anything with that as it relates to Mr. Carden. But Mr. Carden now thinks he's getting the benefit of nothing. He has absolutely nothing to lose, in his opinion, by going to trial. And that's what he would prefer to do at this time.
I understand you correctly, Mr. Gaylor, to say that these are conversations that occurred after he entered his plea.
I'm sorry, Judge.
Did I understand you correctly to say these are conversations that occurred after this conversation about adjourning the plea and adjourning the sentencing as we've done for over 2 years now?
Yes.
That these conversations occurred after the plea was entered?
Oh, yes. No. Do you recall?
Is there anything you want to say with respect to that issue?
Yeah, I will. At the time the plea was entered, the court went through all the proper rights that were given. And I don't think anything was placed on the record at that time regarding him cooperating. However, if there was anything placed on the record at that time, it would have been regarding his wife, Jamie Carden.
And Christopher Maurer.
Possibly Christopher Maurer. Hold on, Chris. And possibly Christopher Maurer. And you will be advised of what he's done in those cases. Subsequent to that, there were conversations that occurred regarding other cases, but those would have been the only two that would have been brought up at the time of this plea. Even if they were put on the record, which I'm not sure they were, but we will acknowledge that those two were discussed in advance of the plea. We will obviously make sure the court is aware and assist in those cases, as well as other cases that he's assisted in, Your Honor.
We're back on the record in file 21-20304-FC, People versus Christopher Lee Ryan Carden. I have had a chance to consider this further, and at this point, I do not believe that I can continue today without a significant risk of there being a reversible error. Having said that, I will adjourn this hearing to 1 week from today, Friday, May 10th at 8:15 a.m. At that point, I will rule on the request to withdraw the plea. In the event that that were to be denied, I would proceed with the sentencing at that time. So that we are absolutely clear. There is a potential that the sentencing hearing will continue on May 10th at 8:15. And so everyone needs to be prepared for that. Court will not entertain any further requests for adjournment, whether those be agreed to by the parties or not.
Thank you, Your Honor.
All right, so as indicated, I am denying the motion to withdraw the plea. First, let me, I guess, have the attorneys place their appearances on the record, beginning with Ms. Wise.
Good morning, Your Honor. Jackie Wise and Doug Hartung on behalf of the people.
James Daly, on behalf of the defendant.
And sir, you are Christopher Lee Ryan Carter.
Yes, sir.
Mr. Carter, have you had an opportunity to read and review your pre-sentence report?
I have.
Have you had an opportunity to discuss that report with Mr. Daly?
Yes, sir.
Are you satisfied with Mr. Daly and the advice that he's given?
Yes, sir.
Do you wish to explain or to challenge the accuracy or the relevancy of any of the information that is in your pre-sentence report?
No, sir.
Mr. Daly, does the pre-sentence report disclose any prior convictions in which there exist any known constitutional defects?
No, Your Honor.
The probation officer has calculated the minimum sentencing guidelines in this case to be from 365 to 600 months or life. Do you agree with that computation of guidelines?
Yes, Your Honor.
Ms. Wise, do the people agree with that computation of guidelines?
Yes, Your Honor.
Before the court passes sentence, Mr. Daly, is there anything you want to say on behalf of Mr. Carter?
Your Honor. When Mr. Carden became involved in these incidences, I know there's speculation that he was the influence of amphetamines at the time because of his behavior. But personally, I believe that this was going to occur no matter what happened. Mr. Carden had created a situation where he had nothing left in his life except trying to protect his children. I'm not suggesting that he had done a good job of raising his children. And I'm not suggesting that he'd been the kind of father that he now knows that he wants to be. And in the future, would like to have the opportunity to be a better father, grandfather, and to enjoy his family if he ever has that opportunity. But when this started out, Mr. Carden already came in with a very strong hatred and dislike for individuals that were abusing children. There's a young woman sitting in this courtroom today that when she was 11 years old and was being abused, Mr. Carden went over to her house and stayed with her and slept on the couch to stop that abuse from happening. So he has a long history of finding it very distasteful. Children are abused like that. And more importantly, in this case, the guidelines are correct as it relates to what the statute says they should be. But the other side of this, the bottom end of the guidelines, are still significant. And we would ask the court to ultimately consider a deviation and go by for a sentence below the guidelines. And there's good reasons for doing that, Your Honor. Mr. Carden, in the 2 years that he has been incarcerated in the jail, has testified numerous times in this courtroom, I believe in Judge Anselm's courtroom, and provided valuable information on capital crimes. There are other capital crimes that Mr. Carden is still going to continue to cooperate with, although and I understand when I say this, that after today, there's no way that anybody can force Mr. Carden to come back here, but he will. He will continue to complete what he has started at the jail. The downside of that is that it now appears as if he has been targeted by organized gangs that he has testified against in this court, and that in prison, they are looking to have him killed. And again, that's nothing the court can do about that. There's nothing that anybody can do about that. But I would ask that the court reflect upon the positive things that Mr. Carden has done since he has been locked up. And in addition to that, one of the reasons that we're here for a sentencing right now is because my personal opinion is the only person, the only institution that has a vested interest right now in having Mr. Carden sentenced at this time is the Lenawee County Jail. They want him out of there. He's been there 2 years. Other individuals have been there longer, and he's been involved in some conflict at the jails. But Mr. Carden has told me that he believes that those facts about his misconduct have been misrepresented to allow the sentencing to go forward now. Mr. Carden knows what he did, and he accepts responsibility for it. And I'm not sure that if faced with the same circumstances today, that he wouldn't engage in that same type of behavior today as it relates to his children and his children being assaulted. Mr. Carden has had a difficult time in life for multiple reasons, but it doesn't change the fact that he does have a heart. His heart is in the right place, and he does not want to see innocent people injured or harmed. You take a look at Mr. Carden's record, and you're going to see he's never been involved in that kind of behavior. What he did should not have been done. Mr. Carden knows that it shouldn't have been done. But at the time he did this, Mr. Carden felt that he had no other way to protect his children. As it is, the mother is in jail for approximately 12 years, while Mr. Carden is looking at a sentence substantially longer than that. And but for the conduct of the mother of these children, Mr. Carden would not have been in a situation to act as he did. And we would ask the court to consider all of these things in passing the sentence. Thank you, Your Honor.
All right, Mr. Carden, is there anything you'd like to say on your own behalf?
Yes, sir. I have 6 children. 5 daughters and a son. They're all honor roll students. My oldest daughter turned her life around. She quit school at 15. Went back to school, graduated. Now she's in a nursing program. My daughter Destiny, she graduates this year. She gonna be off to college. Daughter Trinity, she's like a mother hen. She wants to make sure everybody's all right. She has plans on going to the Navy. Destiny, Danae, is my athlete, and I'm proud of her for being who she is. She knows what I'm talking about, and I'm proud of her for just being herself. And because kids are mean, and despite everything, she's comfortable with who she is, and I'm proud of her. Tessa, she's my little diva. She got to be center of attention. Despite the trauma she's been through, she puts her best foot forward and always has a smile on her face. My son, I see so much of myself in him. And it scares me. I want my son to strive to be a better man than I am. I want my daughters to make sure they marry a better man than I am. But all the trauma and everything my children been through, they persevered and they're thriving right now. And I can't answer nothing more to that. When I found out, when the counselor called me into the office, tell me that my daughter been molested, so many emotions run through me. Mostly guilt. No, guilty that I wasn't going to protect my daughter. I'm in prison and she get violated. Now, law says that I had ample enough time to think about my actions. And that's true. I did. I thought about it every day. I thought about and it fester and brew and boil over. You know, he said I have enough time to make a conscious decision, but there is a flip side to that coin. And I want anybody and everybody involved hurting my daughter to pay. But I didn't take into consideration the innocent people that I would be hurting with my actions. And I'm sorry for that. You know, I failed as being a father. The court could hopefully release me in enough time where I can maybe be a grandfather. Thank you.
Ms. Wise, do the people wish to?
Yes, Your Honor. Your Honor, I do have Vicki Brayman here. She's the daughter of Robert Brayman. She would like to address the board at this time.
Hi. I'm not here to condemn you, to tell you're a terrible person. I know what you did was a mistake, but you did kill my dad and you shot him in the back of the head in a brutal, brutal manner, and you took his wallet and stole his car afterwards. I don't know if you understand that that's wrong. Yeah, he was a bad person. I didn't get along with him actually because he was missing for 15 years of my life, of my adolescence. So I feel bad for your kids because they're going to do the same thing I did, miss out on their dad for most of their adolescence. And it didn't turn out well for me. I have psychological issues. I have major issues with that. And then you went and trumped it and killed him, murdered him. I had to pay for a funeral. I totaled my car a week after because I ran through a red light because I was out of my mind. Like, one more thing that happened to me. No, my dad didn't molest me. No, he did not. Now, he went to prison for molesting somebody. That's what he was charged with. He did his time. He didn't go and he didn't testify against a bunch of other people to get out of his time. He did his time, and then you went and killed him before I could even make amends with him. And I don't think you recognize what you did because you think that the two people you killed don't matter. But they do matter. You can't just go around killing people because you think they did some harm to others. And I'm just really gonna pray for you a lot and your kids. You have a lot of kids. I have 3. You have more than me. But they're going to go through the exact same thing I did because their dad's in prison because you made poor choices. And that's just all I would like to say. Thank you.
Your Honor, Mr. Hartung and I have both been involved. Mr. Carden, Jamie Carden, the Carden children for years. And I struggle so much with this case. I struggle so much with Chris and what he did and why we're here today. I've never seen a more planned out, premeditated killing. And again, I think I struggle with this case, Your Honor, and I just ask Mr. Hartung to finish addressing the court on this issue.
Tough situations tell us a lot about people and how they react. Mr. Carden has a daughter who was so brave. And he stood up in court, testified against the man who had harmed her, and emerged from it, and she's a hero. And there's a lot of ways to talk about this, and I wonder if one of the things we need to talk about at some point in time, maybe not today, is why were these 2 men out on bond? CSC first offenses against young children. Perhaps today is not the day to discuss that, but I know Ms. Borders was so frustrated during that process of being unable to keep those individuals in jail and bonds being set for them either at a PR level or at a level that was easily made when they had done so much wrong to these young people. And the reaction of this defendant cannot be justified. It can be understood perhaps, and maybe even explained, but it cannot be justified. We cannot, in our court system, in our criminal system that we have here, allow such things to occur. Ms. Weiss is correct. This is as premeditated a case of murder as we'll probably ever see. Good Lord, he filmed it. I need Mr. Carden to understand, perhaps he never will, that his daughter testified in this courtroom and put Ernie Black away. And this judge sentenced Ernie Black to life in prison without a chance for parole. He will never get out of prison, ever, because of what your daughter testified to and what Ms. Borders and others in our office did. The same thing would have happened to the other individual because she is a hero. She is a survivor. Mr. Brayman was not involved in that. He was a bystander in this situation. This court has faced a lot of different challenges and has a challenge here today. The guidelines are harsh and the guidelines are what they are. The PRV levels in this case are so high that it doesn't really matter. Mr. Card needs to know that I went to Mr. Jones last week and told him that one of the OV numbers was incorrect and 50 points was taken off the score. We have to do that. We're obligated to do that. But it doesn't matter because your PRVs are so high. It's because of all your previous criminal history. It didn't change the ultimate guidelines whatsoever. Now, we wanted Mr. Carden to testify in as many cases as he wanted to testify in, because as Mr. Jones points out, he is articulate. The court saw it today. He is articulate, he's intelligent, he speaks well, and he's brutally honest. Brutally. So much so that at the end of a preliminary examination that Mr. Carden testified in district court, and a very experienced defense attorney, not from this county, but a very prominent, experienced defense attorney, when he got done questioning Mr. Carden, leaned over to Ms. Weiss and myself and said to us, that man is the scariest mother effer I have ever cross-examined. He has not made good choices in his life. We know that. What do we do with him today? Well, he hasn't completed the task we wanted him to do, but he absolutely has assisted in cases. He assisted greatly in the case against his wife. He testified in that case. He assisted greatly in the Mauer murder case. That case wound up with him going to prison for 20 plus years. Something in that region. It was crucial what he did in that case. It wasn't as crucial in his wife's case because he has his daughter, the hero, who also testified in that case and did an outstanding job. But this court is faced with not only harsh guidelines, the concept of trying to fashion a sentence where in theory that someone could maybe get out of prison in the future, and also people versus Posey case, which relatively recently tells us that not only does the court have to consider the guidelines, the court has to consider within the guidelines themselves where the sentence is going to be proportional. We're almost back to the days of Milborn. So how do you measure the assistance? What do you do? I've been doing this for an awful long time. I have gone through this in many different situations with judges in the past, including Judge Glazer, Judge Timms, Judge Pickard, Judge Gaselka, and it's always difficult. How do you measure the assistance someone get based on and compare it with what the damage that they did? We are not opposed to him coming back and testifying again in cases. I know the Cecil case is set for trial in July. I know there's another really important case that he does have information on, and he's hesitant to make a full on-the-record statement because the people that he would be testifying in that case are even scarier than the people he's testified about before. And if this man over here to my left is fear of reprisal against him or his family, we are talking about some very serious and dangerous individuals. I don't think, unlike Mr. Daly, I don't think he has got to the point where a downward departure in the guidelines is appropriate. Halfway, absolutely. Bottom quarter, probably. But I don't think he's completed the job that he set out to do. He indicated to us that he's going to do these things. And if he does these things, we will never oppose this court or any other court having all the proper information in front of them to sentence somebody. If that requires a resentencing at some point in the future, then that's what we have to do. But we want to make sure that this man is punished for the crimes that he did and receives some consideration for the acts that he has done to follow up. Some of these things that he has done, the cases would have been much more difficult to make. And I'm not going through each and every one of them on the record here today. It wouldn't be fair to Mr. Carden, but he's done valuable service to law enforcement. He's done valuable service to the prosecutor's office and the judicial system here in Mount Lake County. He's tried to make amends. He can't make amends for what he did fully. He's doing what he can. he did say one thing to me that I want to put on the record, because Ms. Weiss and I have gone to bat for him before. And I told him, you know, you have to stop messing up, screwing up at the jail, or you're going to get sent to prison before it's time for you to get sent to prison. And he said to me, he said, I'll do the best I can. And he said, I have been a terrible father to my children. Horrible. All I want is an opportunity someday to be a better grandfather.
In determining the appropriate sentence in this case, the courts considered the seriousness of your offenses, your history, the principle of proportionality, statutory penalty, cost of confinement report, recommendation of the probation department, as well as what's been said on the record here today. The criteria and reasons for the sentence are the nature and gravity of the offense, the discipline appropriate to its commission, deterrence against repetition by you and by others, vindication for the law, and the protection of society. I have reviewed the pre-sentence investigation report as well as the victim impact statements that were submitted by Susan, Jan, Dorothy Brayman, and Kenneth Bush. Mr. Hartung was right. The prior record variables in this case are high. They were 125 on the offense variables and 245 on prior offense variables. Both of those scores are significantly above where the guidelines stop adding additional levels. They essentially stop scoring offense variables at 100 points. Mr. Cardin's were 245, about 150% higher than where they stop scoring at the upper limit. Mr. Cardin's 37 years old. He has 4 prior felonies and 16 prior misdemeanors. Convicted in this case of unlawfully driving away an automobile and 2 counts of second-degree murder. Mr. Cardin was on parole in the state of Ohio at the time those offenses occurred. And the pre-sentence investigation report also reflects that he has had serious substance abuse problems in the form of addictions to methamphetamine and to heroin. Mr. Cardin murdered 2 men, Samuel Compton and Robert Brayman. During his confession, he expressed pride in those actions. Said that he recorded it and put it on Facebook Live. And you referred to yourself as a hero. It was due to the belief that Mr. Cardin's victims were, at least one of them, was a sex offender who had harmed Mr. Cardin's family. Some may agree with that notion, that the actions were justified or that what he did was heroic given the circumstances of the case. But that, in my estimation, is a misguided belief. what happened was not heroic. As you acknowledge today, your own actions contributed to tragedies that befell your children. And well, Ms. Carden may have been the last person, but for a reason that could have stopped it. Mr. Carden's actions and behaviors that resulted in him being imprisoned were certainly a contributing factor. So to excuse or condone what Mr. Carden has done would be essentially to embrace the vigilante nature of society. That when anyone felt appropriately aggrieved or wronged, they could decide when and where and what the punishment should be. That amounts to a rejection of civilized society. Civilized society only works if we give up our right to do violence to other people. Because otherwise we constantly live in fear of others doing violence to us. We're not living in a civilized society, we're living in a state of nature where we can be harmed by anyone, anywhere, at any time. And that would be nasty, brutish, and short, in the words of Thomas Hobbes. So while I can empathize with, or try to empathize, I can never put myself in your shoes and truly understand that, I'm sure. Circumstances that you were in and how horrible it must have been for you to find out what had happened to your children. We as a society cannot tolerate what you chose to do in response. That is what the rule of law in a civilized society provides for and requires. Mr. Hartung made a comment about the difficulty of weighing the value of the assistance that Mr. Carden's testimony in other cases has provided against the damage that his crimes have caused. And he is correct. It is incredibly difficult to do, particularly in a case such as this, where the damage essentially is infinite. Two men are dead. They lost their lives under very violent circumstances. How does one measure that? How does one measure the impact that that has on their family? How does one measure the impact that the sentence coming from that is going to have on your family? And I do believe that the assistance you've provided should count for something. Again, we're counting against a very high price that you have to pay. high end of the guidelines in this case are 600 months, and the recommended sentence in the pre-sentence investigation is 600 to 900 months. Think that when I try to look at the that analysis of weighing the two against each other, and also considering what I had said earlier, that a just and civilized society cannot tolerate what had happened in this case. I believe that the appropriate sentence in this case, and it will be the sentence of the court, that with respect to count 9, homicide, murder in the second degree, that Mr. Carden, you serve 500 months to 900 months with the Michigan Department of Corrections. And the same with respect to the count 10, second degree murder charge. With respect to the unlawful driving away charge, the sentence of the court, that you serve 24 to 60 months with the Michigan Department of Corrections. You do have credit at this point for 1,211 days. You must pay a $130 crime victims' rights fee, $204 state cost, $60 DNA fee, and $450 attorney fee. Those sentences will run concurrent to each other. And there is restitution in the amount of $2,111 payable to the Michigan Department of Health and Human Services for funeral expenses.
So a just civilized society to you is having sex offenders running around?
No, sir. A just
record. My father's been a sex offender since 1990.
He did his time.
Sir, a just and civilized society.
Chris, chill out, man. Chill out. Chris, chill. Listen, chill. Hey, Chris, listen to me. Hey, Chris, chill. Listen, chill. Let me talk to him. He's not gonna do nothing. Let me talk to him. Chris, chill. Listen. Chris, yes, we know. Listen. That was a monster. Chris. Thank you. Hey, I love you. I love you.
All right, everyone.
How long is it?
You know, I love you. You are the most I love
Kids, I mean, you do that to somebody that.
I'm a victim, and that man saved me a long time ago. Long time ago.
Child fucking die. They deserve the fucking.
You wanna fucking do this? Fucking shit, you kids? Come on, bud. Come on. Hi. Fuck you, dude.
This court's fucking bullshit. Fuck this. You that deserve it. Come on.
Absolutely.
Go back to the jail. We need to get back here.
We all die.
No, I do have Mr. Carden's notice of right to appellate review forms. I will give these to the bailiff to give to Mr. Carden. Actually, I need to advise him on records at some point when I need to bring it back. You can say, we need to get some people up here to take care of what's going on in the hallway. We need those people out here.
They have one assistant on the third floor.
Yeah. It tells us feel very safe here.
You stay right where you are.
Yeah.
Okay?
We need more people here. We are back on the record. Mr. Carden, you do have the ability to request an appeal of your sentence. Bailiff's going to hand to you 3 copies of the notice of right to appellate review and request for appointment of attorney form. You need to sign 1 copy of that form that indicates you received your forms. Want to appeal your sentence, you need to fill out the other 2 copies of the form and mail those to the address listed in the form within 42 days.
Nothing further?
Record to reflect, I do have a signed copy of the form from Mr. Carden placing that in the file. There's nothing further.
So in the end, everyone is safe. Everything is rectified, but all the damage is done. And it'll never be undone. It can be repaired to an extent, but you can't undo it. Absolutely tragic.